Did you know that AR in AR-15 does not stand for assault rifle?
What?
It actually, I know.
What?
I know, far too many people don't understand. It actually stands for Armalite Rifle, which is the original manufacturer of the most popular rifle in America. Stephen Halbrook thinks that it should be America's rifle and wrote a book about it. Stephen Halbrook is up next.
Ah, America's rifle. Makes sense. Hey, if you have legal matters that involve firearms, then you need to call California firearms lawyer John Dillon. If you have questions about red flag laws, red gun registration, gun transportation, or maybe you just need to know that your guns are California compliant, call our trusted firearms attorney, John Dillon. John Dillon specializes in California gun laws, 760-642-7150, or you can visit his website at DillonLawGP.com.
So our next guest is one of my favorite authors. I found him years ago when he wrote a book. It's basically the history of the Second Amendment, which I feel is pretty much the definitive book when it comes to the history of the Second Amendment, called The Founder's Second Amendment. His name's Stephen Halbrook, extremely intelligent, interesting guy. We've had him on the show before. We're having him back because he's got another book out. Stephen, how are you?
I'm good. How are you guys?
Fantastic. Thank you so much for coming on the show.
Always my pleasure.
So I'll tell you what, let's just talk about why you think, let's jump right into it. Why should it be called America's rifle?
Well, the AR-15, and that's become a generic term now, of course. There's a lot of varieties, but it's the most popular rifle sold today. I think it's estimated at this point, if we ask about, we do surveys and we ask about AR-15s or similar type rifles, and so I'm going to include the ones that some people like to ban. So all your California non-compliant rifles. I think it's 44 million, something like that.
There are 44. So we think, best estimations, there are 44 million AR pattern rifles in America today.
Well, let's say semi-automatic rifles with features that gun banners don't like.
Okay, all right.
Because when you ask a survey like that, it's got to be very general. And so I think the purpose of these kinds of surveys is to identify how many gun owners have guns that people who want to ban guns, the types of guns. So I would include AKs maybe, but I really don't know. I mean, because it's in the perception of the people answering these surveys. But
yeah, that makes sense.
They're not going to know one from another.
Yeah.
Yeah, right. And certainly the antis don't know one from the other. All they know is it's got that evil, wicked, mean, and nasty, conspicuously protruding pistol grip.
I like that.
Well, not only that, but the other problem is us gun folk, we split hairs. Like, we get way down into the weeds. So,
Right.
It's not technically an AR because, so I mean, yeah, I can see that there probably needs to be a whole agreed upon language set before we can get really, really accurate numbers. Still, 44 million semi-automatic rifles that's significant, right?
Right, and that doesn't include just your 10-22 or just all the other semi-auto rifles. I mean, it's the ones with features that seem to be typical when people think of an AR-15, and there's a lot of gun owners who don't know much about it either. And of course, that was the Colt name. I mean, originally the M16 was called the AR-15, and then it became M16, and Colt in 1964 brought out the Colt AR-15 Sporter, and it's been in production ever since by many other manufacturers. And then, of course, the trademark AR-15 expired a long time ago. But we're kind of like gun people splitting hairs.
Right.
Here's what I would pose, since you're Californians. The conspicuously protruding pistol grip is defined in the California regulations
Right.
As allowing the hand to grasp the handle or the grip. And so they make it to be compliant. You cannot hold the grip all the way around, but if you have this fin block in place where it looks like you're hitchhiking, your thumb is in the up position, then that's legal. Now think about the Second Amendment. Are you trying to tell me that the Second Amendment protects a rifle if your thumb is pointed up, but it doesn't protect the rifle if your thumb is horizontal in grasping the handle. I mean, please. And we've had one court after another uphold these stupid laws, the Ninth Circuit, the First Circuit, Second Circuit. And at this point, the Supreme Court decided the New York State Rifle and Pistol Association versus Bruin case in June, and that invalidated the nanny states may issue handgun carry laws. But the court also had been holding one so-called assault weapon case and two magazine cases, and told the lower courts to get it right and to redo those cases. So the assault weapon case, so-called, was out of Maryland, and they just had oral argument. I mean, the Supreme Court said in the Bruin case, is it under the text of the Second Amendment? Well, yeah, it's an arm, the right of the people to keep and bear arms. These rifles are arms. And so you've got to find something at our founding period where something that at least equivalent to, they banned guns like this, or they did something that was so close to the modern restriction. And of course there is none. These lower courts have been upholding these laws based on some kind of balancing test where the Second Amendment always loses and the government interest always wins. And so we've got one of the magazine cases from California, another one from New Jersey.
Yep.
And the Supreme Court told these lower courts, look, you didn't do it right. Let's try this again. And I fully expect these lower courts to try to obstruct again, just like they did after Heller was decided. But we'll see what happens. I mean, I think at some point the Supreme Court's going to take on this issue.
Wow, of the assault. So our case is the Miller case. That's San Diego County Gun Owners. That's our case. That's the one we got a favorable ruling, and then that's the one that they're going to revisit.
Right. That was sent back down to District Judge Benitez.
Yeah.
And they had a hearing on Monday.
Right. And we know how he's going to, we know. In fact, I mean, Stephen, I know you read the decision. His original decision was almost cut and paste on what ended up being the Bruin decision. So we know it's going to go in our favor. You think the Ninth Circuit they're going to push back, or you think they'll comply?
Well, look what they did when that case first went up to the Ninth Circuit. You had a 3-judge panel. The good guys won 2-1, but then it went en banc. And every case that goes before the Ninth Circuit, if the panel decision wins, the en banc court will overturn it. And there's apparently 52 cases or so, by one of the judges' counts. Every one of them, the Second Amendment loses. Cases that have been before that court, either the full court en banc or just a panel decision. But it's an en banc. It's like an automatic en banc rule if the panel gets it right. So, I'm looking for them to try to obstruct some more.
Wow. So what would that look like? They'd appeal it, or they'd delay it, or what do you think that'd look like?
Well, so what's going to happen? The Supreme Court in Bruin said if it's within the words of the Second Amendment, the text, then the burden is on the government to try to prove by historical examples from the founding period or shortly thereafter something like that same kind of restriction. And so just to use the Bruin case for an example, it's about the right to carry, and it's always been the rule that the courts could restrict gun carrying in their courts. I mean, that goes back for centuries. So there's not a problem. That's a so-called sensitive place. And so if you take that reason and let's apply it to this case, like, can you find me a historic example kind of like that where they banned any type of gun? Hey, I'm going to tell you something. They didn't ban any guns. They didn't ban cannon in those days even. Now, according to the Supreme Court, Heller, if a gun is commonly possessed or typically used for self-defense, then it's protected. Okay, so you can argue cannon aren't protected, even though they could be sold legally at the founding. But rifles, pistols, and shotguns. I mean, hello.
Yeah, really.
These are commonly possessed. They passed the test. And I got another thing to inform Joe Biden, because he thought cannons were banned. You can still own a cannon today. It just has to be registered with the ATF. So they were not even restricted at the federal level until 1968.
Well, did you notice in this latest round, in the last few weeks, this latest round of hey, we want to ban guns, the terminology was they were staying away from assault weapon, they were staying away from weapons of war. They're just going with semi-automatic now. That's I can't believe we have these semi-automatic guns, and no one needs a semi-automatic gun, and that's the term, which is accurate. But man, I don't think they realize. I mean, what 80% of pistols, rifles sold today are probably semi-automatic, and that's what they're talking about banning now.
Right, and they've always been after that goal, but there were too many of them to ban. That's why the federal ban from '94 did not ban the Ruger Mini 14. There were too many people who had them, but they figured they could get away with banning rifles like the AK series or like the AR-15 because not as many people had them. But at this point, I mean, they've always wanted to ban semi-autos. In fact, this is not a ban, but it's a restriction. In the state of Oregon, they simply took the definition of semi-automatic rifle and they inserted the word assault. They took a perfectly normal definition for semi-automatic, and then they introduced the word assault. And what is that? What the hell does that add to it? It's just a derogatory term.
All right, Orange County Gun Owners is dedicated to preserving and restoring Orange County self-defense rights. If you live in Orange County and want to help defend and restore the Second Amendment, join. OCGunOwners.com/join. Orange County Gun Owners is more than supporting the lawsuits by the Second Amendment. They have developed an effective infrastructure that focuses on local outreach and activism. Volunteer at a shooting social, at a gun shop, and tabletop, and help more pro-gun local officials get elected. Become a member today. OCGunOwners.com/join. All right, we got Stephen Halbrook back with us, author of America's Rifle, trying to educate the masses that an AR is not an assault rifle.
So talk to us about the book. What are you? What is the hope? Or what is the message you'd like to get out about the book? What are you looking to accomplish with the book?
Well, I'm hoping to help educate the American public, but also more particularly lawyers, judges, people who are doing litigation on the subject, because there's a number of things going on. First of all, I got involved with this topic right when it started. In 1989, California passed the first state ban, and we litigated a case called Fresno Rifle and Pistol Club versus Vandy Camp, and the Ninth Circuit said the Second Amendment doesn't apply in our state. Okay, and so eventually the Supreme Court resolved that in the Chicago case from 2010, McDonald. Mm-hmm. And but I wanted to trace the whole history of this, because what were we up against in those days before the Heller decision? And it was just a complete denial that of the Second Amendment had any value, whatever, or any meaning. But then we go up into different phases, and what the book does after going through that initial phase, which talks about how that term assault weapon was invented as a propaganda term by the Violence Policy Center. They said, well, people will be confused because these AR-15s look like M16, so we'll just, use that kind of illogical reasoning to try to mix people up, and they think they're full auto, and they think they think if you shoot a pumpkin, it'll blow it up, and all these things they used to show. You remember what they used to do on television. Right. And so, but then the book goes into the text of the Second Amendment and the Supreme Court decisions, and then way back in history to the English forefathers who there was always a struggle between the monarchy and the freedom of the people, and eventually they had a Declaration of Rights in 1689, But then when our country started to be founded, our colonists came here and they expanded on those rights. We go through a lot of different periods of history. And what's incredible, of course, the Supreme Court set for the meaning of the Second Amendment says, look at the period of when the Second Amendment was adopted and shortly thereafter, and let's look at what the founders had in mind. But if we go through even years after that, we have the development of, let's say, the Winchester rifle with multi-shot. You can fire them fast. At the same time, we have new states coming into the Union. They're all declaring the right to bear arms in their constitutions.
Yeah.
Like, don't tell me they didn't have in mind Winchester rifles. And then we get to the 20th century, and we have repeating semi-automatic rifles with detachable magazines. And we never had a single state ban any of those, basically until 1989. And at this point in history, we only have 7 states. I mean, these are still outliers, although unfortunately some of these are large populated states. But if you look at American history, even in the 20th century, when they passed the National Firearms Act, the proponents of that understood that you couldn't just ban guns. And so they restricted certain guns like machine guns, and they said you have to register them. But it was not until the federal ban in 1994 that they restricted ordinary semi-automatic rifles. And,
right.
and then on the other side of their mouth, we have the civilian marksmanship program where they're still selling M1 Garands.
Yeah, you can get a Garand delivered to your front doorstep.
Right, like the greatest battle rifle ever invented. And so, and even Congress, as many restrictions and as many bad things, intrusions on the Second Amendment as they've done, the only time that they ever banned a large number of rifles or ordinary firearms was the so-called assault weapon ban, and even that expired. And so when you look at the overall picture, this is no way any part of American history and tradition to do this. And so we have these we had only 6 of the states that had bans, and then the week after Bruin was decided, the governor of Delaware thought, well, he didn't read the decision. He didn't get the memo, obviously. So he signed their assault weapon ban into law. So now we have 7 states, and of course they're superficial. They can't even make up their minds in terms of their definitions. And anyway, I've got a lot of this in the book, and it
sounds excellent. Yeah. I have a question for you. Okay, so the case in I want to say it was the late 30s, and I think it was also called the Miller case, where that's when they decided that you could ban short barrel shotguns, right?
Well, they didn't even say that. They said, we don't have anything in the judicial record in this case that it was a militia weapon.
Right.
And they had the idea that if it's a militia weapon, then the National Firearms Act might be invalid as applied to that. But remember, the short barrel shotgun was required to be registered and you had to pay a tax, but it was not banned.
Right.
They've never said
correct.
that you can just ban them.
Right. Correct. You're absolutely right. But in essence, in very layman terms, weren't they basically saying that if the firearm doesn't have a military use, then you can highly regulate or ban it?
They seem to have suggested that, but it was more in the negative, that if it was a militia-type weapon, ordinary military ordnance, then there would be a problem with the National Firearms Act. I mean, if it was some other gun that didn't meet that, then you'd have to litigate it and see what the story was with it. But because there were a number of state judicial decisions saying that militia weapons were the highest protected under the Second Amendment, because you've got the militia duty, this is defense of the country, defense from tyranny, and the whole controversy up until 1989 was about handguns, basically, in terms of like the anti-gun movement. That's all they cared about. They said
ban handguns,
little guns bad and long guns good. Then all of a sudden they flipped. All of a sudden rifles are bad.
So do you think now? Of course, with the Bruin decision, it's kind of, it doesn't matter. But do you? I used to make the case, and I'm curious what your opinion is on this. I used to make the case that it was a mistake for us to describe AR pattern rifles or anything close to an AR rifle as less than something you would use in military use. They'd say, oh, no, it's a sporting rifle. Oh, no, a 5.56 caliber isn't really that powerful. Oh, no. We'd never use a semi-automatic rifle, for in the military. I used to make the case that was a mistake, because if you can't use it for military or militia use, then that's actually a case for being able to heavily regulate or ban it. That if it's just simply for sporting or just simply a collector's item, then it's not protected as much by the Second Amendment. What do you think about that case? What do you think about the argument I was making?
Well, I can see it both ways, and here's the way I look at it. A single-shot Chipmunk 22 bolt action has militia uses. You got to start somewhere, and anything you can do to enhance the ability of the people to keep and bear arms and for self-defense, for hunting, for recreation, for militia, for defense against tyranny. That's why all of these guns are protected. And with the AR-15, it's got maybe some extra protection because how many people know how to use the charging handle to get the cartridge into the chamber? I mean, people brought up on other types of actions or bolt actions, just as an example. I mean, it does look like kind of a mystery at first. And it was only when for me, it was not until the M16, I'm getting older, that was a very novel way to charge a rifle, was to have that charging handle. I mean, your Mini 14 was completely different. Most semi-autos were different than that. So I think some things like that and learning to use the sights, I think that enhances national defense. That's why, in
100%.
fact, the civilian marksmanship program sponsors matches where they encourage this kind of rifle. And one reason is to introduce people to military rifles. The big difference, of course, is that they're not full auto, and that's why the idea that they're only good for military purposes. I mean, no military in the world issues that as just a semi-automatic as a standard service rifle.
So let me ask you. I'm looking forward. I haven't read your book yet. I'm looking forward to it, and I can't wait. Again, you're the Founder's Second Amendment. That book is one of my. I tell everybody to read it. I truly think everybody should read it. Everybody. It's fantastic. So I'm really looking forward to it. But stepping away from the legal, the explanations, etc. Just you personally, why is this important to you? Why why is writing this book and winning this battle and getting this information out to you personally, why is it important?
Well, because I'm an American, and the Bill of Rights protects our rights, and the Second Amendment has a very specific purpose. When all else fails, if free speech doesn't get you there, and if the normal Constitution is overturned, I mean, our forefathers fought a revolution to overthrow tyranny, and so we have principles of liberty that many of us were brought up to believe in, and we value our Constitution and our Bill of Rights. This is a fight worth fighting. There's so many people, lawyers and academics, who talk about the First Amendment, although it's getting unpopular nowadays. In the last few years, the First Amendment is no longer popular on campuses. But
well, plus you wanted to be on Gun Owners Radio, too.
That's why I wrote the book.
That was the main reason.
Steve, where do we find the book? Where do people? What's the name of the book, and where should people go to buy it?
America's Rifle, the page for the AR-15. You can get it on Amazon, or you can get it any other way. It's on Kindle and paperback.
America's Rifle, the case for the AR-15. You can get it on Amazon or wherever fine books are sold.
Won't find it at the airport.
Probably not.
Just thought I'd throw that out there. Hey, it's great talking to you. Can't wait till you bring out your next book.
Okay, guys. Good to talk to you again.
All right.
Take
Merry
care.
Christmas.
Thank you.
Thanks for watching this clip from Gun Owners Radio. You can watch us live every Sunday from 4 to 6 p.m. California time, right here on our YouTube channel, or if you're in the San Diego area, you can listen to us on 1170 a.m. We're also available on your favorite podcast platform for free. Don't forget to like and subscribe so that you can help restore and protect the Second Amendment, not just in California, but across the country.